And thank you for staying with us. In New York City, there are some new laws going into effect within this new year, such as rent laws and employment law issues. We want you to be connected to it. So what can we expect with these new laws? And the question is, how can they affect us? So here now, giving us more information and providing insight on these topics is attorney and host of Today's Verdict, my friend, David Lesch.
So, buddy, I missed you last time.
I know, glad to have you.
But I have a couple of statutes I want to talk about today, particularly how it's affecting the court system itself. So we're going to talk a little bit first about the Housing Stability and Tenant Protection Acts of 2019. That was the sweeping reform legislation that took place in June of 2019, basically taking a lot of power away from the landlords in the city and giving it to the tenants.
Right.
Basically, in terms of deregulating an apartment, rent control, rent stabilization, how much the landlord could charge, how easily the landlord can have you move, the type of renovations the landlord can make, and then charge you back on your rent. All these really were covered in the act. But what really wasn't discussed and hasn't been discussed is really why I'm here today, is talk a little bit about your ability to bring a lawsuit or actions as a result of the overcharge. Most people don't understand that. They understand that the laws have been changed, but what recourse do you have if it turns out that the landlord has been overcharging you in rent, especially if it's a rent-stabilized apartment? This is very, very important. In the past, you really only had 2 to 4 years to look back to get the monies that you were owed for overcharges or for the landlord pushing you out of the apartment. You got 2 to 4 years worth. It's been changed. Now you have 4 to 6 years. So you can go back a full 6 years to get any of the damages that you have as a result of the landlord overcharging you for your ability to stay in the apartment. Now that's important because the damages are what's called treble damages, 3 times the amount. So you're getting 2 extra years, 3 times the amount each year. So that's a huge increase, and the courts are really doing this to punish the landlords who've been taking monies out of your pocket by doing renovations that you didn't really need, renovations in the lobby, overcharging you now in your rent, or just forcing you out of the apartment because they wanted to put a relative in who they haven't seen in years, or it's a really distant relative. This act, which now protects you, gives you the ability to be able to bring an action against your landlord and get a tremendous amount of money back. Now, if it's in an individual, it doesn't seem like it's so much treble damages, but if you have what's called a class action and all the tenants get together, and they hire let's say one or two attorneys, and let's say you have 20, 30 people in a class, you're talking hundreds and hundreds of thousands of dollars against these landlords. So the landlords are really at a disadvantage now when you're going to court, which leads to the next part of the act where lawyers are involved and the court system is involved, and that involves discovery and your ability to go into the landlord's office and go through all the records to see what it is that they've done to the apartment and whether or not they're really in compliance. In the past, they could only go back 4 to 6 years. Not anymore. The courts have ruled that you can go back all the way to when the actual unit was deregulated. That could be 10, 20, 30 years ago. You can go right back to so if the landlord doesn't have those records, you're really at an advantage as a tenant. And that's very, very important, because now what a class action attorney does is he finds, let's say, 20 or 30 units in a building. He asks for the discovery of all the units. Landlord may not have all the discovery, or the landlord may have sold to a new landlord. Now that new landlord may be on the hook. So this is very, very important. So
and we're seeing several cases like this.
Several
right now.
cases are coming through. There's one, Dugan versus London Terrace Gardens. This was one where the complex was actually constructed in 1931, stabilized in 1974, and then slowly the landlord was taking back the units, and sure enough, was not doing it properly. And they looked back only 4 to 6 years in terms of records, and the attorney says, I want to go farther back. I want to go all the way back into the 80s. And the judge allowed them to do that, all the way back to look, and they didn't have the records.
Right. And we're hearing landlords are definitely pushing back. They've got some lawsuits trying to counter as well.
They're trying to, we're becoming a very tenant-friendly city at this point. I don't know how much damage they're going to do in terms of overturning the act. I don't see it happening. So, all right, so that's a little bit of an update. The second statute I want to get to is the new sexual harassment statute, which is called the Stop Sexual Harassment in NYC Act. A lot of people know about it. It really comes out of the Me Too movement. It basically talks about making sure that your employees know that they have a right to bring actions for sexual harassment. These cases have gotten into the courts. There's one in particular, one particular case which basically ruled that you no longer have to prove, as a woman or a man who's being sexual harassed, that the conduct was severe or pervasive. Now you only have to show that it subjects you to inferior terms of employment, a much lower standard.
Right.
Inferior terms of employment is much different than a really severe or pervasive type of behavior by your employer. That's big.
And what are the penalties on that?
Well, you know what? You can end up getting not only your emotional damages, because let's say you start seeing a psychiatrist or psychologist because of it, you end up having to leave. You're not able to find another job. I mean, you can hit the employer with punitive damages. Very, very big. Another part of the act is also, remember, the employee has to make sure that you know your rights. He has to give you the course. You have to take the class. You have to make sure that you're given all the documents. Employers must make sure you do that. And the last part of it that I really like, I think it's very, very important, has to do with the non-disclosure agreements. Many, employers think they're quick and they're smart, and they say, okay, fine, I'll give you the money for so that you don't bring an action against me, a lot of money, but you can't tell anybody. There's a non-disclosure. Well, the act limits your ability to do that to an employee. You have to give them 21 days from when you settle the case for them to decide what they can do it. And even if they do sign it and they say, fine, I won't say anything, they have 7 days to revoke. Makes them think about it a little bit more. And the last part of it, which I also think is important, is arbitration. A lot of these employers put in their employment agreement that if you want to sue me for sexual harassment, you got to go to arbitration. We don't go to the court systems. Why?
Right.
Because the jurors give a lot of money for this kinds of thing. They're very, very giving. Well, New York City courts have been knocking down that arbitration clause. Not the federal courts, but the New York City courts.
Right.
So these are very, very important. I mean, these two statutes are going to be affecting us for years to come, and they're starting now, 2020.
You'll come back and unpack some more of this for us in the near future.
Always
David
here
Lesch,
for you.
coming up on today's verdict, anything real?
We were talking about, sadly, the things that happen to children when they're abused in foster care, when they're abused by priests. We had a former president of the New York State Trial Lawyers on last week. Great show. Take a watch.
All right, David Lesch. All right, now, if you need any answers to difficult legal questions, David does have you covered. You can connect with him on Facebook and Twitter at Today's Verdict. And of course, you can tune into Today's Verdict on Tuesdays at 6:30 p.m. right here on BronxNet TV. And we're taking a quick break. And coming up, we're going to sit down with a career strategist discussing tips for goal setting. So if you haven't got your goals, get ready, get your pen out. We're going to help you. Be right back in a few.